I'd like to give a quick shout out to our sponsors who make these events possible. Edmanity, the breakthrough system to marketing success like nothing else. The most powerful marketing and branding assessment tool available in the industry. Check them out at edmanity.com. Master Book Builders helps authors achieve their book publishing dreams, win awards, garner great reviews, and even reach #1 bestseller status. Master Book Builders, good things come to those who write. Visit masterbookbuilders.com. Merrill Research, we help companies evaluate new product concepts and hone strategic communications through the unique use of research, nonverbal intelligence, and AI. Visit merrillresearch.com. Michelle Lee Coaching, increasing sales up to 300%, close deals faster, build stronger and more meaningful relationships with a proven system, state-of-the-art technology, and all the training you need to exponentially grow your business. Visit my.bankcode.com/Boss Academy. Pro Video Pages. Quickly build trust with prospective clients. A Pro Video Page can shorten your sales cycle and attract more of your ideal clients. Check them out at provideopages.com. And Websites by Cellians. Output-driven, outcome-based. Remember, one size fits none. We leverage ROI-based digital marketing and B2B sales to build a website that's going to help you transform your business. Visit Cellians.com. Check out our amazing member benefits at bossacademy.com, the last boss you'll ever need. As chair of the firm's privacy and cybersecurity group and a partner in its intellectual property group, Amy B. Goldsmith guides clients through the legal aspects inherent in data privacy, cybersecurity, and using artificial intelligence tools and platforms. Amy assists clients in building immediately recognizable brands, developing desirable products and services, and devising strategic IP plans to mitigate risk. With respect to IP risk management, Amy advises clients on U.S. and non-U.S. trademarks due to diligence, patent go-to-market strategies, and copyright compliance. Amy, I want to thank you so much for taking out time to come in today. I know this is an important conversation, and I want to encourage all of us on the call to welcome Amy B. Goldsmith to Boss Academy.
Thank you. I love the vibe of the group. Let me say that the first thing that I usually ask people that I've never met before, the very first thing that comes out of my mouth is, how may I help you? I like people. I was trained at my parents' knees to interact as a very young child. They would have parties every weekend, and my brothers and I, we had to be there. We had to interact with people. We had to learn who they were, be polite and respectful. And so we are all, in our own ways, entrepreneurs. So in my over 3 decades of practice, I found that this has been very helpful in helping clients solve their legal and sometimes their non-legal problems. So when we look at AI, you've got 2 types of people. People who want to just adopt certain AI tools, and other people who are like, oh, no, we can't do this. This is dangerous. And I work with both. So my first question to the group is, are you using any AI tools? So just raise your hand and tell me which tools you're using. Don't be shy.
ChatGPT.
Okay, and why?
It helps me with outlines. It helps me get my thoughts together. It's a way for me to put ideas out there and get, feedback on them and to see where I can take them.
Are you using it to generate any content?
It generates outlines and sometimes title ideas and newsletter ideas, and I generally then take whatever it delivers to me and rewrite everything.
Okay, so that's really perfect, because that is one of the first takeaways. If you are going to be using any of the large language artificial intelligence models, the generative ones, then you can take what they've given you, but you must curate it. You must revise it. You must rewrite it. Why? You don't know the source. So if we're looking at traditional copyright infringement, let's say you had a book and that book had a lot of interesting content and you wanted to write an article that is using content from that book. You can do it the right way or a wrong way. The wrong way is taking lots of content and then putting maybe one or two of your own comments. We call that copyright infringement. With ChatGPT, the danger is you don't know the source of the information. If you just use it as is, you could be committing copyright infringement. This is putting aside all of the lawsuits against the companies that have actually used everyone else's material for training content. So there's one in California by authors, there's another in New York by authors, and those are going forward. Because the concept there is that you used my work without permission to train your generative AI model. And we're going to see where that goes. New York Times is sued. Authors, actors, anyone whose information has been used by these generative AI models, they have sued. We don't know what's going to happen there. Let's say that you are using an AI model to generate images. So Canva, Midjourney, any of those new AI, DALL-E, any of those models, and they're generating images for you. Again, you don't know the source. Let's say you're a stuffed animal manufacturer. You ask the AI to create an octopus with a head, a body, and tentacles. That octopus could be from your competitor. You won't know. Now, what happens on the, can I protect the octopus? The answer is maybe. What the Copyright Office guidelines say now is that if you can specify for us what AI has created and what you have created, we'll give you a copyright certificate of registration for what you've created. So putting aside the infringement issue for a moment, let's say you really like the body, but you're going to draw original head and tentacles. You would have to tell the Copyright Office, AI created the body, but I created the head and tentacles, so I'm getting protection for the head and tentacles. So if we look further down the road with this and we look at, the competition, they're going to be able to see your copyright certificate of registration if they do the appropriate search in the Copyright Office, and they're going to be able to see that you only have protection for the head and the tentacles. So what are they going to do? They're going to make changes so that the head and tentacles are different so that they don't infringe. They're going to design them. But you still have a problem because you do not know where that body came from. This could be a bestseller for you, and someone else could say, oh, wait, that looks suspiciously familiar. That's our body. And they can sue you. So using AI to generate images, we are not quite there yet. What I think is going to happen with image generation is companies are going to have their own instance of AI image generation based on their own body of works. What the Copyright Office will do with that, no one knows yet. But from an image generation standpoint, we want to make sure that you are appropriately curating and changing whatever images AI creates. We, as attorneys for years, this is what we've been doing. People come to us and say, oh, I've got this source book, I've created this. Is this okay, Amy? There's no rule of 7 where you change 7 things. No, that's garbage. It's the question of what would an ordinary observer see? Now, let's say you want to use generative AI to create brands. Little different story. You can use anyone or anything, including generative AI, to create a brand for you. You still have to search that brand in the jurisdictions in which you might want to sell a product or service. Because there may be someone out there who has already chosen that brand, and the AI machine may have gotten it from that potential competitor. So you still have to do a clearance search, but there is no inventorship issue with regard to using AI to create trademarks. Now let's look at patents. The Patent Office, honestly, I'm scratching my head with regard to what the patent office has done. The patent office has said right now, well, what we're looking into doing is humans still have to be inventors. So humans are going to design the prompts, and the AI is going to give you an idea. And maybe if you develop that idea, that will be human created and not AI created. So it's like a ball of string. Which string was created by a human and which string was created by AI using this prompt? We don't know the answer to these questions yet. And it is really important because we are already using AI to sort through chemicals that may be the next best antibiotic. So if you're using that prompt and you're sorting through chemicals that have a particular genetic sequence that we think might be good for, let's say, MRSA, which is something that is not really responding to very many antibiotics these days. And the AI suggests, let's say, the addition of other chemical compositions to it. Well, then is the AI the inventor? Because under the patent law, under our Constitution, only humans can be inventors. So, or was it the prompt that encouraged the generative AI to come up with that particular addition to an existing antibiotic? So all of these questions for us as intellectual property attorneys are unanswered right now, which makes it very difficult for us to be able to advise clients what they need to do and how they should be looking at invention and creation using AI. Now, let's go back to the images. Anita, that was beautiful. Where did you source the images?
Enviro Elements.
Pardon?
Enviro Elements.
Yeah.
Okay,
Envato.
so you have a license to use those images.
Yes.
Yes.
Of course.
So that is one of the first questions I always ask my advertising and creative clients. From where are you getting your images? Because most people, especially if they're not sophisticated, will grab images from the internet. And again, we call that potential copyright infringement. You have to have a license to use the images. Dealt with something recently, which was really interesting. There was an independent Facebook group that teachers created regarding their use of a particular product that their school district purchased. And so the teachers are themselves using images, their own images of the children. And yes, the school district gave permission and the parents gave permission for their images to be used in this fashion. But the product says, "Ooh, this is interesting. Can I do this too?" And the answer is not automatically, "Oh, well, they have permission, I can do it." No, they would have to go out and get separate permission to use these images because the license that the school district has does not automatically flow down to the license for the product. So we really have to tease this string, all of these strings, to look at everything very deeply to see what you can do with what's online and what has been created by AI. And it's really interesting for us as attorneys to get into this whole new area and apply all of these old concepts to this new area. Now, you may say, Amy, I've heard that Copilot and all of these others are offering IP indemnities, which means that they'd be responsible if there was an infringement. But what does the indemnity actually say? What I teach my clients to do is look at those vendor terms. If you're using any AI product, you must look at the terms of use because that indemnity could be very restricted. It may not apply to you if you actually make any changes. So we want to be very, very careful on pulling on all of those strings. And back to what I started with, which was using AI to create text. We want to be really, really careful there because the text that AI comes up with may be your competitor's text. And copyright lasts a really long time. we're talking 9 decades. So even if it's pulling from a competitor that's out of business, there still may be an existing registration. So we want to make sure that we're curating and that we are actually making those words our own. So I see some questions. Eva? You're muted.
Yeah, yeah, I had to turn it on. Yes, it's Eva. Thanks. First, I was answering your question to us generally, which was, what are we using? So I actually do always curate anything I pull. So that solves that issue. I mean, it sounds like that's what you were saying. I mean, whenever I get something from ChatGPT, if I'm doing something it's helping me to create some text or some. So for example, not too long ago, I needed to create an agreement that I would sign with other people. And so I said, okay, please create an agreement that has this type of rules in it, these type of whatever items, right? And then I used that agreement with some editing of it for the direct use, for our use. To me, that's a practical, standardized type of document.
So this is
what
not necessarily
you winced when I said that. So
yeah, the use of AI. So each state has its own rules regarding how agreements are drafted, what should be in the agreements, and how they're interpreted. So when we prepare agreements for clients, we understand what state you're in, what rules are going to govern that agreement, and what needs to be in that agreement based on litigation that has gone on regarding the terms and conditions of agreements. I would
I was adhering to the dealing with what type of location we were dealing with. In our case, it was an international thing. So I did it under the parameters of, please provide, we need to create a standard agreement that is such and such within this.
Right. But the problem of it is that ChatGPT hallucinates.
Sorry, ChatGPT what?
Hallucinates. It lies.
Hallucinates.
It wants to create what you want to see. So it's going to put in there what you want to see, which is not necessarily correct.
So what you're saying is that if I write a prompt that says, please create an agreement for 3 people that covers, X topic and this topic and yada, 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 that isn't enough to produce a useful, simple type of agreement that is usable?
It may get you what we would call the whereas clauses, which are, this is what I want to do, this is what you want to do, this is what we've decided to do, or, the SOW, the statement of work, but it won't necessarily give you, unless it's curated by a lawyer, the exact correct terms and conditions that you need. It's because it hallucinates.
All right. Well, I don't want to get into the weeds, but
yeah.
not in terms of specific terms and conditions, which I would decide upon, or we would decide upon amongst us. But what I'm talking about is, you're not referencing, you kind of winced when I said it at first. So this is not a wince. I mean, it's not an infringement to have a standard agreement that I pull and then edit.
It's not an infringement, but
right.
It is not wise. A lawyer should look at that agreement and bless it.
No, I'm not. That's a separate issue. We're not talking about that. We're not talking about that. You're talking about infringement. So
yes,
it's not an infringement if I'm going and poring over a document and I'm pulling, it's a tool. So that document is supposed to be a tool that I look at and then specify for what our needs might be. That's not an infringement.
It should not.
Which I don't think it is. Right. Okay.
Yeah.
But
I want
the infringement issue comes into creative. The infringement issue comes into creative writing. Yes.
Right.
Okay.
But let's put it this way. There are a lot of companies whose agreements are online because they're public companies, and you've got databases that require them to put up certain agreements. If someone were to grab that because it matched something, a prompt that they put in ChatGPT and they use that agreement, that would be a not great from an infringement standpoint. So just because a company has posted something does not mean it's free for everyone to use. They're required to put certain things online in certain government databases, and that does not mean that the general public has the right to use their agreements which have been carefully drafted for their particular purposes and typically have copyright notices in them. Now, we're no longer required since 1989 to put a copyright notice in, so you won't know whether it's protected or not, but the assumption is that it will be.
Thank you. I want to keep this moving because there's other people have their hands up, but
Yes,
that's
please.
a great point, Eva. Thank you. David Schneer?
I'm sorry, Paul, was that me?
That would be you, buddy.
All right, I'm sorry, I was coughing. Hi, Amy. Great topic. Paul, can I share the screen for a minute? I want to show Amy some stuff.
Sure.
So can you see this, Amy?
Yes, I can.
All right. I'm going to blow this up. Here's what we're doing. We are a research company, and I do all the qualitative research in the company, all right? And what we're doing is we're using AI to help me understand when a respondent is being less than truthful with me. Okay. So how does this work? Well, what you're seeing here is almost like an EKG readout of emotions. You can see the yellow in joy. You can see the blue, which is a high level of engagement. So how do we use this? Let me show you some stuff here. We asked respondents, when you think of a company like Texas Instruments, what comes to mind? And this is the word cloud that came up. And we use these words to create this image. And this image is being created by a proprietary large language database.
Mm-hmm.
And so everything that we do is being turned inward. So like every time I interview somebody and I see a emotion of disgust, that gets captured, classified, and put into the large language database so that we can learn from it. Tell me, am I at any risk here?
For what purpose are you doing this analysis?
Well, we got hired by a $12 billion microprocessor company to determine if engineers actually do emote, because the classic notion of an engineer is that they're linear, they're rational, and they make only technical decisions. Well, we actually proved that wrong. These guys are completely emoting, and we're capturing it. And you can see here as this guy is talking, let me go back. As he's talking, we're capturing, sorry.
Okay.
But you can see,
Yes.
let me see.
All right. Very, very interesting. So.
Yeah, and I don't know if David prefaced that he runs a market research company, that so this is the type of work that they've integrated his experience with body language with AI, and they're leveraging that. Got
it. So we have a number of state laws now that have not yet been passed that are going to relate to AI-enabled profiling. For instance, in Washington State, AI-enabled profiling in this law that has not yet been passed is the automated or semi-automated process by which the external or individual characteristics are analyzed to determine, infer, or characterize an individual's state of mind, character, propensities, protected class status, political affiliation, religious beliefs, immigration status, or employability. And the goal of this law and other types of laws are to be transparent if an AI tool is used, for instance, in employment decisions, either for hiring or firing or raises or bonuses. So these laws, if they are passed, may apply to the work that you are doing.
Even if
So,
we have
yeah.
people agree to be videotaped.
Well, agreeing to be videotaped is fine, but these laws may say that you have to disclose the AI tool that you are using and the purpose of the use. So, Pennsylvania introduced March 7th. The Pennsylvania Department of State would be directed to establish a business directory of businesses from 1 person to gazillion that operate artificial intelligence systems in the state. And AI is defined as the theory and development of computer systems and tasks that normally require human intelligence. So these laws are being written, as broadly as one could think. Again, they're not in place now, but AI tools that look at and assess people are going to be, at some point in the near future, subject to these laws. Now, right now, if anyone is using chatbots, California requires the disclosure of the use of the chatbot. So in that little bubble that comes up, it has to say, I am an automated chatbot. You have to explain that it's not a human. You have to explain that it's automated. So if you are using AI tools, then you've got to be aware of these potential laws. And the other thing that you need to do, especially if you have more than a core group of people who know exactly what everyone is doing in the company, is a model AI acceptable use policy. So who gets to decide if you're using an AI tool? What is the purpose of that tool? What information is being entered into that tool? Is it personally identifiable information? Are you training your employees, your C-suite, your officers, your board? Who is going to report non-compliance with that policy? So, and then we look at bias. Is the tool subject to unconscious bias? The tool itself. So the New York City has an automated employment decision tool law. That's already effective July 5th, 2023. And it prohibits employment and staffing agencies from using automated employment decision tools in employment decisions for New York City residents or anyone who's being considered, unless a specific bias audit and notice requirement is met. So the company has to actually have bias audits every year, assessing whether there's a disparate impact. And since we have a lot of case law on disparate impact in the employment context, we know what to look for. But that is an existing New York City law that applies to use of AEDT only in the city, or where the job is in an office in New York City, full-time or part-time, or the job is remote, but the location associated with it is an office in New York City, or the employment agency you used is in New York City. So we've got this new bias audit in New York, which applies to the use of an AI tool. So really, really interesting with regard to, the use of AI tools in New York City. So, and the EEOC is also looking at this, looking at all of these tools. So your businesses really need to understand the purpose of the AI tool. If you're using an AI tool that is provided to you by another company and you didn't develop it homegrown, what promises are being made to you? What indemnities are being provided or none? What is your company's responsibility via the use of these tools? So I think Anne has a question. She's next on my list.
Yeah. Well, I think it relates to indemnities. I wrote this down when you started to, you're shortly into your initial sharing. But what do we as small business owners need to have in place? I'm thinking, oh, well, I'm glad I hired a, long, very, good graphic designer to design my logo. Well, what if that person used AI? Is there anything that I need to have in place, or I hire somebody to do, or subcontract with somebody to do some writing? Are there some simple things that we should have in place?
Yes, so you definitely should have an agreement with them saying that they take responsibility if something screws up. The problem is that if you're using people who are solo or small business, what is the value of the paper? What are the value of those zeros and ones? Because they may not have the ability to indemnify you. Now, business insurance, general liability business insurance, they do have some coverage for intellectual property infringement, but it's very, very limited. And buying IP policies specifically is very, very expensive. So what you really want to do is make sure that what they're giving you, they have curated. They have to save everything they've done. So if they're using an AI tool, they have to tell you. They have to show you their prompts. They have to show you what they got back. They have to show you the entire stream. The same thing with patents that I spoke about earlier. If it turns out that the patent office adopts what it thinks it's going to adopt with, yeah, sometimes it may work if you use prompt engineering, we're going back to, not that we ever should have stopped, we're going back to lab notebooks, writing down everything that you've done and complete curation from beginning to end. And that's what they have to provide to you to make sure that you know that what they've done is going to pass muster, because their indemnity is probably not worth much.
And so likewise, if we're using AI, we shouldn't throw anything away, and we should know exactly where we can find it should we have to prove anything.
Remembering that ChatGPT specifically hallucinates, and it admits that it does.
So a quick follow-up question for a small company with, say, 20 employees or more, do you think that there's a need for somebody to be the AI person, and what department would that fall under?
Depends on what you're doing. So use of AI tools for employment decisions lives in HR.
Right. Okay.
Right?
I get it. Thank you.
If it's creative, then it lives in creative, but you should absolutely have an acceptable use policy. We, in my firm, we cannot install anything without permission of IT. And everything gets vetted, because obviously we've got some pretty critical information that we do not want, to be hacked.
Yeah.
So
thank you very much.
You're welcome, Ann. Anita, I see
That's
you
great.
have
We got a couple more quick ones.
Daniel,
real quick, and then Luis.
Hi, Himi. Thank you so much for the session. It's been very eye-opening. I hope you can hear me clearly.
Yes.
Okay, quick one. From the way the discussion has been going, I noticed that the problem here is when it comes to using AI for creative work. So the first question is, so where is the balance between using it and the balance where you have to use it and you don't get to cross that red line? Number two is, as a creative, are you trying to say that the best way to go about this is to have your original work, then use AI on your original work so that it does not go too off, such that it begins to infringe on other people's rights?
Daniel's a copywriter, so it's really obviously something that applies to what he's doing.
Yes. So if you're asking, let's say Grammarly, which has been around for a long time and is in essence an AI tool. If you're using Grammarly to edit your work, that's fine. That there's no issue there, because Grammarly is not writing it for you. It's editing it, suggesting word choice here or there. No problem with Grammarly at all. The issue arises when it's more than editing. when it is actually creating blocks of text for you. You don't know where that text came from.
From scratch.
So you really have to modify that text. Using ChatGPT for outlines, great usage, no problem. But you've got to supply that text, or you have to curate and edit the text that it provides to you enough so it would not be considered an infringement. Images, much better if you start off with your own images. However, if it's suggesting changes, you still don't know where those changes came from. So it really depends on looking at it from the perspective of, oh, everything it suggests may come from someone else and may be an infringement. So I'm going to take this as an idea generator and then make my own. So let's say you asked it, you gave it a purple unicorn and you said, I want the unicorn to be a lot of different colors, and I want the unicorn to have a longer leg, things like that. Probably would be okay, but we'd still want to do a comparison and we'd still want you to make changes. So AI in certain circumstances may not save you a lot of time because the curation is going to add time to the process. The point is you have to make it your own.
And just in full disclosure, I just noticed Adela Marcy was able to join us. He's in the UK, writes amazing copy, and a lot of his clients are in the US. Daniel's in Nigeria, and so he writes copy. His clients, some of them are in the US. So I'm sure that opens up another whole can of worms there too.
Yes, well, if you're going to be circulating the copy in the US, then you're subject to US rules. Copyright outside of the US, a lot of countries are on the Berne Convention from 1989, so the rules are fairly similar. So, just because you're in a different country does not mean that there isn't potential for copyright infringement for materials circulated in that country.
Yeah. Luis?
My question is about email marketing, because a lot of the softwares have this AI component that allows you to use the AI to generate an email marketing campaign. Now, I don't do it, but I've been wondering maybe I should because it would save time. But what do you think about that?
Are they using your content or are they generating content for you?
Right now, I'm writing and doing the campaign completely myself. But they always have that button on there. Do you want to have AI generate this for you?
Right. And so it really depends on whether you're giving AI all of your content and then having it, create new content for you based on your content. So that is a use case that doesn't have a lot of risks, assuming that the instructions that you can give say only use my content. So that's a perfect use case for AI because it's your content. The AI is just reshuffling it. So no chance of infringement there. If it's going to start to blend your content with other content and you don't know where that other content came from, then we're in the danger zone. So as I said at the beginning, if we have internal AI systems using our own content, perfect use case.
Phenomenal copywriter and good friend of our community and long-term member, Adela Marcy. It's been a while since we've seen you, buddy. Good to see you back. You got a question?
Thank you for having me. Hey guys, Brian, great to see you. Paul, it was always great to see you guys. Hey, Michelle, I don't know if she's still on. I think she might have jumped off. But oh, there she is. Hey, hope you're all doing well. Lovely seeing you all. I am sorry, I just jumped in right at the end, Amy, but there was like a wonderful opening of a question that came up that I was really curious about. So I write, because I live in the UK and I'm registered over here, but I write copy that's all my own work. We don't use AI. It's all freehand, its own stuff that we do. Whenever we write for a US company or client, whatever happens therein, there is a limited liability that we have put in place. So essentially, if anything does go wrong, we have limited liability. Say, for instance, the client runs it, changes out the offers, but uses the bones of the copy, we can't really be sued for it. My curiosity is, does that still extend does that still work more or less, or have the rules been changed because of the AI rules?
So if for the client to change your copy,
Yes, like say for
Yes.
instance, they take something and they rewrite some of it through AI.
right? So again, there, it's a risk because you don't know, in essence, how that is being rewritten and from where that other information is coming. Again, if it's just
Okay.
grammar, no problem. If
Oh
they
no,
are
it's the actual
actually,
pieces.
pardon?
It's actual entire sections. They're just basically
Right,
running
so
it
you
through
don't,
like a, yeah.
if I were you, I'd make sure that you were only responsible for what you wrote and the client is responsible for what they wrote.
Okay, wonderful. Okay, so the liability risk that we have already put in place
There is a risk
is
there.
Yeah.
Again, if you're not using an AI tool that's specific to that company with all of that company's information. If you're using ChatGPT or any of the other models, again, they take from the entire internet, and there are lawsuits regarding infringement that are going on now.
Okay, that's actually really great to hear. That just means that we're, thank you for answering that. That actually means that we're still doing the right thing, which is a good thing.
Okay.
Wonderful. Thank you. Great to see you guys.
We definitely have gone over the time a little bit, Amy, and I'm not sure what your schedule is, but if there are more questions, do you have a few minutes or do you need to?
I think I do. Hold on. Let me just check my calendar. You never know what might be popped in when I'm not looking. Let's see. I've got a 1 o'clock.
Okay. Well, we'll wrap this up fairly soon. Anybody have any other questions? One thing that popped in my head is now with online tools like AI tools being able to even help with programming code.
Yes.
That opens up a real Pandora's box because let's say that somebody has a proprietary software they developed and it's released online somewhere, and somebody is using AI to write code snippets for a video game that ends up producing millions of dollars in sales, and that gets uncovered that is code that was extracted. I assume that puts them at great risk.
Yes. I mean, you've got it. So posit one, that proprietary code was somehow posted online. So, number one, for anyone who writes code, let's try to keep it as a trade secret so that, and we use least privilege, where only the people who need to know have access, and it's not posted all over anyone's internal intranet. And, we want to keep it in its own silo with limited access. But let's say it is posted online and somebody uses it. First of all, I'm not quite sure if we'd find out about that usage unless they publicized it. But the whole writing code, code is copyrightable. Most people don't realize that. You can protect original, you can protect original code, and a lot of companies do. We're not required to in the copyright application, produce the trade secrets. Those can be redacted. We're only required, depending on the length of the code, to produce either the first 10 and last 10 pages with redactions, or the first 25 and last 25 pages with redactions. And then that code is protected, and you can use that to sue, let's say, a departing employee that grabbed the code and is using it.
What about algorithms from like an assessment?
Right. You can, the algorithms or trade secrets, you can redact those. So you can get protection for code. Can you get copyright protection for code that is written based on a prompt from you? And right now, the Copyright Office answer would be no. Different from the Patent Office. Copyright Office right now says, you've got to tell me what human created, okay? What AI created, no. Again, Constitution says human authorship. So the Patent Office, again, is this whole ball of string. The Patent Office, if you presented prompt engineering that came up with something that might be patentable, the Patent Office is thinking about being able to parse that. From a practical perspective, I have no idea how that would work.
Yeah, Brian, that's something you should definitely be looking at with your algorithms for your assessment, finding a way of protecting that. But you had something. We'll wrap up with Brian's question, and then we'll let Amy close.
Algorithms or trade secrets should be protected as trade secrets. If you want to protect algorithms via patents, you are disclosing them to the public. And it's not something I generally advise. Trade secrets are forever, as like the Coke formula, as long as you keep them secret. So the algorithms, keep them secret. And then you're golden, and make sure your employees Only those who need to know, need to know.
Just put them in
Don't
that
get
vault
my
next to the
algorithm.
11 herbs and spices recipe that you have, Brian.
Correct.
You'll have to pry it from my cold, dead hands. Yeah, interestingly, we met with patent attorneys when we launched our company, and they said the same thing. They said, look, you're going to have to disclose this thing, and they're going to change one little piece of it, and you're going to be suing people the rest of your life.
Right.
So
Good attorneys.
Okay. Yeah, they were. Yeah, the bill was pretty good too. You know, but
The
they were,
patent exam
it
was
was
the
the right
hardest
advice.
exam I've ever taken, and it was open book with a 30% pass rate.
Wow. Oh my God.
So I have a quick question for you. We're designing a little chat bot. His little name is going to be YesBot. And YesBot is before you take our test, he's just a little helpful bot that's just going to answer questions about the test. You know, how long will it take? You know, is it going to be fun? And, you know, but when he gets questions like how high is up, or calculate pi to the last digit, he's going to say, yeah, I'm just a little bot. I can't handle, that's way above my, we're going to build a sense of humor into the little bot. So he really won't be intentionally trying to access ChatGPT for anything really meaningful. Is there anything we need to be, as we're programming this little guy, aware of or worried about?
So you need to say it's automated. So you need to say, I'm YesBot, I'm automated.
Okay.
So that's number one. And then number two, if it's going to be pulling from ChatGPT or other generative AI sources, then in your terms of use, you should have a section about YesBot, telling the people, telling the potential consumer how YesBot is being developed and what it's doing and what AI tools it may be using. So these state laws are all about transparency, disclosure. And if you are, if your website is going to be aimed at Europe, that's a whole different conversation, because Europe has an AI Act that is going to go into force in the next couple of years, and it's a whole different conversation than what we have in the US right now.
Can we just say something like, YesBot is for your use and entertainment, and he may or may not be accessing AI for the answers that he gives you?
Yes. Yeah. Automated. Okay. Yeah. It's just
okay.
As you described it to us here, that's what you want to put in your terms of use. So
I think the bigger hurdle for you, though, is, Brian, this is not your software creating the chatbot, and this is something that the guy that you're working with, you're going to have to probably get him involved in disclosing where he's sourcing from.
Yes. And the other
are there occurrences where GDPR... Go ahead, Amy.
One more point on this. I don't want to miss it. You need an assignment from anyone who creates anything for you, whether it's using AI or not. If you don't have an assignment, you can pay that person $1 million and you don't own anything. You need an intellectual property assignment from every third party who is creating anything for you in order for your company to be the owner. And I really want to stress this, because I had a case, general practice firm came to me and said there's a dispute between the software developer of this $1 million project and our client. They can't resolve it. What can our client do? And I said, your client has to go hire a new developer. I looked at all the documents. There was no assignment.
So when I pay the little chatbot development guy, he should give me an assignment saying everything we're...
You should give him the assignment, not the other way around. Okay. You want to be in control of the text.
Okay, so we say everything you develop for us is our intellectual property.
There's legal language, back to that other question from Eva. There's legal triggering language that should be used to make sure that you own everything from soup to nuts.
Yeah.
Okay.
That's amazing. Amy, I'm going to let you close this out. Anything else that you wanted to cover today that you think we should be aware of?
Well, feel free to ask me any questions. Happy, as I said at the very beginning, how may I help you? Just email me. My information is is all over the internet. If you just look at me and my firm, Sonia Goldsmith, Tarter Prinsky, and yeah, feel free. Happy to answer any questions. I think it's really important that we use AI the right way, in a way that, you know, protects you and your business.
Yeah, we have another group we're looking at launching that'll be a little larger companies that this will really apply to. So if you're open to it, we may ask you to come back and speak, and we can maybe come up with some more structured questions to give you in advance. So, but this was amazing, very important conversation, one that I think is not being talked about enough. And there's been a lot of, within this community, I mean, Tom Collins is always, he's a former attorney, recovering attorney, as he likes to say. But notice he's named after a drink too. I don't know if you caught that, but but he is always talking about how there's a lot of risk around this. But hearing you talk about it from a very quantifiable and practical application, I think is super important conversation. So thank you again for coming today.
My pleasure.
All right, guys.
Well, so much. You've been great.
Well, happy Friday to you all. Great questions, everyone. This was really, I'm sitting here ready to go back through the recording, and I'll be getting that up this weekend because I think this is one that we need to definitely revisit. So, Amy, thank you again.
You're welcome. Lovely to meet everyone. Take care.
Thank you.
Have a great weekend.